Okay, seems like our sound is in order and we can get started. Hello, everyone. Good morning, good afternoon, or good evening, depending on where you're located and tuning in from today. My name is Untitled Lang. I'm the Executive Director of PHAP, which is short for the International Association of Professionals in Humanitarian Assistance and Protection. Great to see so many familiar names in the list in the chat. Hello to everyone that I already know who's joined us today, and a very warm welcome to those who are joining us for the first time. Great to have you on the line, and we look forward to an excellent discussion coming up here in this hour we have together. So as you've seen, this is the first session of a new series of online events produced by PHAP, targeting practitioners aiming for a more advanced understanding of laws and policies related to or affecting humanitarian assistance and protection of civilians in armed conflict. Before we launch into the subject matter for this session, we'll go through a few quick points regarding the use of this interactive online platform. First of all, we hope that all of you will take the opportunity to pose some questions to our speakers. You can use the Ask a Question box in the lower right-hand corner of your screen. Just type your questions in there, and then we'll get to as many questions as we can in the Q&A portion at the end of our session today. For clarification questions, of course, we can also bring those in throughout the event. So feel free to submit questions at any time throughout the session. And if we have some we can't get to during this short hour, we'll see what we can do to work with our experts to get responses afterwards in writing. So please do feel free. Second, we have some poll questions that will be appearing throughout the session. There are a couple of test questions here. As you can see, we have some that are in multiple choice format, others that are in free text response. We'll have a few of these appearing throughout the session. It's a great way to get your thoughts and to get your feedback on some key questions about your experience with the subject matter. So as participants in the discussion, please do keep an eye out for those and do participate when they pop up. Great. So then moving to today's session, we're looking at counterterrorism laws and their impact on humanitarian action. And very pleased to have with us two colleagues coming from PILAC, that's short for the Harvard Law School Program on International Law and Armed Conflict. First of all, Naz Modirzadeh, who's the founding director of PILAC and regularly advises and briefs various international humanitarian organizations, UN agencies, and governments on issues related to IHL, to human rights law, and counterterrorism regulations relating to humanitarian assistance. And she's been working together with her colleague Jessica Burniske, who's Law and Policy Associate of PILAC, and who's been carrying out legal research and policy work focusing specifically on this intersection between IHL, counterterrorism law, and humanitarian action. And as you read, I'm sure in the event description, Jessica and Naz have recently published a pilot empirical study on the impact of counterterrorism laws on humanitarian action, and that's going to be providing us with the meat of the presentation and discussion today. It's very exciting to have both Naz and Jessica with us today to share the results of this study and some reflections regarding the implications. So specifically looking at the objectives then of our session, to back up a level here, we're looking first of all to increase familiarity with the main concepts related to counterterrorism law that can have an effect on principled humanitarian action. Second, we're seeking to build awareness of the existing challenges and risks faced by humanitarian organizations in relation to counterterrorism measures. And finally, seeking to build awareness of the policy implications that counterterrorism laws and regulations can have on humanitarian policy frameworks. So thanks to Naz and Jessica for helping us to try to achieve these objectives. And I'll begin now by handing the floor over to Naz to get things started with some brief thoughts to frame the session.
Excellent. Thank you so much, Anharid, and hello, everyone. It is always a pleasure for PILAC to be able to present our research to PHAP, its members, and its colleagues. We always find that it's incredibly fruitful for us to receive your feedback and reflections and answer what are always new questions that don't occur to us. So it's a real pleasure for us to be here. I just wanted to take a moment to situate the research and give you a sense of what we're planning to do in these 30 minutes that we'll be speaking, both to meet these objectives, but also hopefully to share some insights from our recently published research. As many of you in the audience know, PILAC has been leading a project called the Counterterrorism and Humanitarian Engagement Project for some 5+ years now, with the generous support of Swiss FDFA. And we have briefed PHAP a number of times on the research we've been doing. One of the things we found, particularly in 2015, 2016, as we were doing research on topics related to the intersection of counterterrorism and humanitarian action, was a sense that there was a real demand both on the government donor side and on the humanitarian side for evidence. There was a sense that there was a significant gap in terms of empirical or quantitative research on the impact of humanitarian action stemming from counterterrorism laws and policies. As many of you know, there was, of course, a very significant study by OCHA and NRC published in 2013, as well as a number of other important studies on this issue, including some more specific research on issues relating to the financial sector, but there had not as yet been an attempt to engage in quantitative research. So our study was an effort both to do that research, but also to see what would it take to be able to engage in a full-scale global quantitative study of impact in the future. What would be the resources required, and what would be some of the challenges that might be faced in such an endeavor? So I want to qualify what you'll be hearing here today by saying it was a pilot study, and so we were trying to anticipate what might be future challenges in a full-scale global empirical study. But we also think that we found some indications of impact that are worth discussing and engaging with, even at the level of a pilot study. So the way we'll proceed is my colleague Jessica, who spearheaded most of our research and analysis and worked closely with our empirical specialist in developing the survey and analyzing the survey results statistically. She will cover some of our key findings from the research, as well as our methodology and some of the areas where we found either surprising outcomes or outcomes that might point to a need for further research. And then I'll spend about 10 minutes at the end talking about what some of the policy implications of this might be, and some of our reflections, having worked in this area for quite a few years now, on what the path ahead might look like for the humanitarian sector. With that, I'll hand it over to Jessica.
Wonderful. Thank you very much, Naz, and thank you to PHAP for having us here today to discuss our empirical study, and welcome to everyone who's joined us. As Naz said, we've undertaken our study with several goals. We realize, as Naz noted, that there's been considerable work undertaken to examine the impact of the counterterrorism laws and humanitarians have faced, particularly in areas where designated terrorist groups may control access to territory and civilians. And what we aim to do is to supplement those efforts by helping to determine the impact or lack thereof of counterterrorism laws and regulations on humanitarian organizations and their work. And so, as Naz noted, this is sort of an initial attempt at a pilot study to assess some of these issues. And what we wanted to try to do is to provide an initial analytical framework to really measure the impact of counterterrorism laws on humanitarian work. And also, as we'll discuss a little bit later, some of the challenges that we've encountered in undertaking such research. So at the outset, I'll just note some of our key findings, and then I'll go into detail a little bit about what the specific questions and some of the answers that we received. We believe that further research on these issues is clearly needed, but Our survey respondents indicated overall that counterterrorism laws have a real and tangible impact on the work of humanitarian actors, and that in some cases those laws have reportedly chilled humanitarian assistance. Many survey respondents also reported a lack of clarity surrounding counterterrorism laws and policies in terms of their understanding of what those requirements entail. And this really persists despite a reported awareness of the laws and also efforts by organizations to educate their employees and colleagues about the implications of those laws. As Naz noted, we felt empirical data in this field would be incredibly useful. We've noticed a trend by many key donor states, the United States and throughout the European Union, to really engage in evidence-based policy making, to use empirical data to inform policies and laws that are being developed. And so we hoped that this might assist in that area. We also believe that in the humanitarian realm, that information that can be gathered in an empirical study can inform consultations with donors, giving both humanitarians and donors a greater sense of the real and perceived risks of humanitarian engagement, and particularly in conflict zones where designated terrorist groups control territory and access to civilians. We also believe that empirical data can help these organizations develop risk assessments and really navigate their work in these high-risk environments. We also believe that empirical data can help shed light on areas that may need changes, both on the part of humanitarian actors as well as donors, and what those changes might actually look like. And ultimately, we believe that this empirical data and future efforts in this arena can help provide clarity to humanitarians in an area that's been very legally and operationally difficult. And there's been really a lack of information regarding the impact of counterterrorism laws on humanitarian assistance. So just briefly, I'll touch on the methodology that we used. We worked with experts in empirical research to develop our survey, and the questions we drafted were really informed by conversations we've had with donors and states and humanitarian actors throughout our years of work on the CHE project. Our survey was about 30 questions long and included some multiple choice questions as well as open-ended responses. It was available to individuals online, and they could take it in one of 4 languages: Arabic, English, French, or Spanish. And we really sought to distribute this survey quite broadly as possible. We identified potential respondents through identifying humanitarian organizations operating in a wide range of environments and across the globe. And we also worked with our internal CHE project working group, as well as professional organizations like PILAC, who assisted us in distributing the survey. We received approximately 500 responses from individuals in nearly 50 countries and territories across the world. And our respondents were quite diverse, not only in their geographic location, but also in the roles that they had within their organization. We saw a range between senior management to project management and implementation, as well as representatives of legal departments and other specialized areas. And this just sort of illustrates very briefly the geographic distribution of some of our respondents. And as Naz noted, I might go through some of these slides rather quickly, but this information is contained in our report, and you can see the charts and the information available online. This just emphasizes, I think, that many of our respondents have been engaged in the humanitarian sector for quite some time. We asked whether they had worked at other humanitarian organizations within the past 10 years, and many indicated that they had. And most respondents, 71%, indicated that their responses were based on their current work. And this chart, again, just illustrates the diverse range of respondents that we had to our survey, the various roles that they had within their organization, and what their obligations and responsibilities entailed. And this one may be difficult to see. Again, this is in our study, but it highlights where respondents felt comfortable identifying where they were located. This is the range of countries and territories that were represented amongst our respondents. So first we asked respondents whether counterterrorism law directly affected their work and the work of their organization. And here we found a majority of respondents said that it did. It did affect their work and the work of their organization. We also wanted to ask about the familiarity of respondents with counterterrorism laws and regulations. And here we saw that most respondents had some degree of familiarity with those laws, from 26% saying they were very familiar to 38% saying they were moderately familiar, 24% said they were slightly familiar. So we had a range here in terms of knowledge of the laws and regulations that were in place. And this just shows a brief breakdown of familiarity with the laws based on position in the organization. So you'll see that senior management is slightly more familiar with counterterrorism laws than perhaps working level or field level staff. We also wanted to know whether organizations had implemented policies, procedures, or training regarding counterterrorism law to really understand how organizations are informing their employees about these issues. And here, again, a majority of respondents indicated that their organization had put in place such policies, procedures, or training. We also asked whether counterterrorism laws in the respondent's jurisdiction provided clear direction to humanitarian actors on their legal obligations. And here we saw 55% of respondents answered that they did not provide clear direction. And we wanted to explore this a bit further and ask those respondents why they felt that counterterrorism laws did not provide clear direction on their legal obligations. And here the majority of respondents indicated that unclear or vague language was the primary cause for this uncertainty. But other issues that were given are insufficient guidance from donors, that the laws themselves conflicted with humanitarian principles, that there was an insufficient awareness or training surrounding the laws, and they also pointed to a lack of exemptions for humanitarian work. As I noted, some of our questions involved open-ended responses, and so this one in particular highlights the breadth of counterterrorism laws and the penalties that accompany those laws, and that those often lead to the so-called chilling effect on humanitarian action. This response, again, highlights some of the difficulties, particularly working in high-risk environments like Syria, where navigating some of these issues posed by counterterrorism laws can be very difficult for humanitarian workers. And this response highlights some of the dilemmas that are faced by humanitarians in terms of reporting perhaps interactions with designated terrorists or individuals of terrorist organizations, or providing humanitarian assistance, and sort of the tension that arises between those two areas. And finally, this response highlights something that I'll touch on a bit later, but this perceived contradiction between counterterrorism laws and international humanitarian law, and that those laws make it difficult, in this respondent's view, for humanitarian actors to operate impartially and with neutrality and independence. We also asked whether the respondents accessing information and documents through their organization to sort of gain this kind of clarity about counterterrorism laws. And we really saw a really broad range of materials that are available to respondents that they're using to access. And this sort of talks about the clarity of those various resources. We also found that some resources available to respondents were reportedly unclear, starting from donors, even to internal organization documents and information obtained from colleagues or other humanitarian actors. One area where we really saw a clear coalescence around a particular response was this issue of whether respondents felt they needed more information and engagement on counterterrorism law and policy. And here, 89% of our respondents indicated that they did want more engagement and information on these issues. We also wanted to ask how counterterrorism law affected the respondents' organization commitment and adherence to humanitarian principles. And 60% of respondents indicated that counterterrorism law did affect their organization's commitment to humanitarian principles. And when we asked how it affected their commitment, 91% of those respondents said that it weakened their commitment to humanitarian principles. So this was another area where we saw a very clear response, a perceived impact of counterterrorism laws on humanitarian principles. And this is another open-ended response that sort of touches on that issue, and it highlights some of the challenges that organizations face in terms of this tension between violating counterterrorism laws and also continuing operations. And this response to our question really emphasizes this contradiction that's perceived between humanitarian principles and counterterrorism laws. And finally, this response sort of touches on the tension, particularly in territories where designated terrorists may control access to the territory itself, but also to the civilian population, and how organizations are negotiating access to the civilian population and the difficulties that arise in terms of maintaining adherence to humanitarian principles. And this response touches on the issue of vetting, which I'll talk about a little bit more later. It says that vetting really impacts the independence of organizations in this respondent's view and their ability to work effectively with local partners and gain access to the population. And we found that organizations are using a really broad range of strategies to comply with counterterrorism laws, from oversight to restricting engagement in particular areas to obtaining a license or exemption. And generally, respondents indicated they could be forthright with their donors regarding concerns that they were encountering in high-risk environments. 61% of respondents indicated that they could. And we also asked whether counterterrorism laws had caused the individual or their organization to forego or end programming in particular areas. And here we had sort of a range of views. 38% of respondents indicated that it had. And when we asked how it caused them to forego or cease activities or programming, people pointed to the end of programming in particular areas, or the loss of funding, or this perception that they can't violate counterterrorism laws. This open-ended response highlights really some of the dangers that humanitarian actors are facing in some of these high-risk environments, and the prudence, to use their word, that this respondent and their organization uses to help them meet their objectives. And this response touches on some of the difficulties working, again, in high-risk environments like Syria, where there are certain constraints between engaging with local partners. This touches on sort of direct instructions from donors and governments regarding counterterrorism laws and policies and how that's affected their work. Again, we saw many respondents indicating that they had changed their programming based on those discussions. And respondents indicated really a broad range of activities that they're engaging in to comply with counterterrorism laws, from risk mitigation strategies to vetting, training, and legal compliance. One area that we thought was very striking, and I think as Naz may note in her remarks, that may warrant some future research, is the amount of time that organizations are taking to comply with counterterrorism laws. And we found that 60% of respondents said that the time that they were spending was substantial. So that might be another area for future research and exploration. 65% respondents also indicated that they were required to vet local partners and recipients of aid. And many people found that this vetting slowed their operations or was time-consuming and inhibited work with local partners. Here, 65% of respondents noted that counterterrorism laws were affecting humanitarian negotiations within their organization. And this touches on some of the varied responses that we received on the particular issue. Some felt it was beneficial, and some noted that it had affected those negotiations to a great extent. We also saw that many respondents indicated that counterterrorism laws pose certain risks for them, both in the form of reputational risks and legal risks and security risks. This was fairly evenly spread across the respondents, although some said that they didn't know or that there were no risks associated with the laws. And the majority of respondents also indicated that counterterrorism efforts have affected the availability of funding to certain areas, beneficiaries, and partners. And here, when we asked sort of more about that particular issue, respondents indicated that there was decreased funding or risk aversion associated with that, or decreased programming, or both. And we also asked whether counterterrorism laws have affected the individual's work or the work of their organization, if they've left their operation unchanged, or if it's chilled or curtailed their work. And here 69% of respondents said that it had chilled or curtailed work in certain environments. 19% said it left their work unchanged, and 9% said it actually improved their work. This highlights one of the impacts of counterterrorism laws on humanitarian organizations, that it's led to a conservative decision-making process and a reluctance of organizations to engage in certain environments. And finally, I'll just conclude with some comments in terms of areas for future research. We think that certainly in conducting our study, we encountered some challenges, particularly gathering information on really sensitive issues from such a diverse and diffuse audience, and the level of knowledge and comfort that people might feel in discussing these sort of complicated legal issues, and the difficulties logistically in distributing the survey to many humanitarians, and particularly those actors working in certain areas such as conflict zones. And so we distributed the survey through a broad range of mechanisms and organizations, but we believe future research would benefit from even broader distribution, which would reveal more reliable data. And this could help inform the humanitarian sector about ways to really move forward in terms of how to shape these laws and where to take the sector as a whole in terms of their response to counterterrorism legislation. And I believe with that, I'll turn it back over to Naz for her comments on the study.
Excellent. Thank you so much, Jessica. And I would definitely encourage you all to continue engaging in the chat. Jessica can now step into my role of speaking there. I thought I would just very briefly say a few words on our broader reflections on this research, and I should note here that I'll be injecting my personal view just as someone who has been engaged in discussions on this topic, both with government representatives and senior representatives from the humanitarian sector for some time now. Hopefully this will spur some discussion. Certainly our sense is that many of these issues remain not only controversial, but as Jessica noted, very difficult to talk about in any kind of an open environment for a variety of very understandable reasons. So first, our sense is that up until this point, this issue has been largely treated as a quote-unquote problem for the humanitarian sector to deal with. That is, that the donor approach and the state approach has been to say, we will impose new restrictions on you, and it will be your responsibility alone to determine how you can comply with those restrictions. As you saw, the survey bears out an intuition that I think many of us had, that the guidance coming from donors has been confusing and minimal on many of these issues. One of the possible implications of this survey is to suggest that this is just as much, if not more, a quote-unquote problem or a dilemma for states and for donors, and that moving forward, it may be crucial for the humanitarian sector to seek to share risk with donors as opposed to simply taking on all of the elements related to restrictions and other kinds of legal and policy impositions from this kind of law. Second, what we found is that because many of these regulations are for practical purposes communicated to the humanitarian sector through grant agreements, and let me just say a word about that. Many of the counterterrorism laws that we were talking about here have a kind of a dual personality. On the one hand, they may be in criminal laws, meaning that anyone who satisfies the elements of the crime for support or other kinds of benefit being offered to designated terrorists would be responsible for a criminal action in a particular jurisdiction or jurisdictions. But then they also have a different life or personality in grant agreements and contracts. And one of our senses is that there may be a perception on the part of the humanitarian sector that if these counterterrorism policies are embedded into grant agreements, there is a sort of take it or leave it aspect to it. If you want the money, you accept these restrictions, or you don't get the money. And that may have created a sort of a problematic dynamic in terms of how we engage some of these issues. Third, we have heard from many of our interlocutors in the humanitarian sector that donors have indicated that counterterrorism clauses are non-negotiable, that when they get to those clauses in their contracts, they essentially have no choice but to accept them as written. And yet, what we found is that those organizations that do push back on some of the language or seek to clarify it or nuance it actually might be successful in negotiating or altering that language just like any other elements of a contract. A second part of this is that many have indicated to us that donors have said, unless you can show us that counterterrorism regulations are resulting in loss of life or starvation amongst the beneficiary population, we do not want to hear about so-called impact that is merely administrative. And one of the implications of this research might be that the next step is to actually clarify the costs of compliance. What does it take in a monetary and in a personnel sense for humanitarian actors to comply with these regulations, particularly those humanitarian actors that have a variety of government donors with different and overlapping regulations? We have heard some remarkable stories about the lengths that organizations have gone to in order to comply with some of these restrictions, and at least initial research indicates that the dollar amount of compliance may be far higher than either the humanitarian sector or donors are currently aware. A few reflections on how humanitarian actors might think about these issues moving forward. One is whether or not humanitarian actors feel that they have appropriate risk assessment tools. There is an excellent document from the Norwegian Refugee Council that engages the question of risk management and discusses some models for doing that. We also know that there are a number of UN humanitarian agencies and NGOs that have innovated around this issue. Second, whether or not humanitarian actors wish to engage in an open and frank dialogue with donors. So we discussed this a bit in the chat, but there seems to be a real debate within the sector about ambiguity. There is a school of thought that says confusion and lack of clarity is an advantage to the humanitarian sector, because as long as no one knows what the law says, and as long as no one understands what the implications of these policies are, then we, the humanitarian sector, will benefit because either the issue will simply be ignored and unenforced, or we will get sort of the benefit of the doubt. The other school of thought says not at all. Ambiguity is dangerous and destructive, and the humanitarian sector is increasingly exposed to serious legal, personal security, and other risks unless and until the sector is able to truly understand the legal obligations implied in counterterrorism regulations. So I'm not suggesting what the right answer is, but I'm suggesting it may be time to seek to come up with some kind of sector-wide agreement on this issue. Finally, there may be an interest in continuing to develop information about this issue, but also understanding that unless and until humanitarian actors are able to develop strategies and solutions for how to address these tensions, and I think that's an incredibly difficult thing to do, training may have an unintended negative consequence. So let me just briefly explain what I mean by that. You see that in our pilot study, a significant majority of the respondents indicate that they desire and would welcome additional training on this topic. Yet, in our view, these issues can be so alarming to humanitarian professionals when they are briefed or trained on the risks that they may face legally regarding these issues, that unless organizations are able to offer some kind of strategy or solutions when they provide these briefings, it can be very paralyzing for staff to learn about this issue, but then not be told how they should be dealing with the issue. So there may be kind of a sequencing element to consider here. Finally, a lot of our research over the years has indicated that many organizations are dealing with these issues in isolation. Now, what do I mean by that? Many humanitarian actors will come to workshops, will come to discussions on this topic, and may participate or may engage on some of the issues, but frequently will not discuss the internal decision-making approaches or internal challenges that they are facing as they deal with government restrictions and regulations and policies. And one of the questions that may be facing the sector, as it seems that counterterrorism restrictions are increasing, particularly in conflicts such as those in Syria and Iraq, there may be a real benefit to agreeing to some kind of forum where humanitarian actors feel comfortable sharing some of their concerns and sharing more honestly and forthrightly their approaches to negotiations with donors and government interlocutors. I'll close there. I'll invite you. There's additional reflections that we've made in some of the comments to the paper, and we can certainly discuss those. But I think now I'll hand it over back to you and Herod and see if you'd like us to go into the question and answer portion of the discussion.
Okay, terrific. Thanks a lot, Naz, and thanks so much, Jessica, for the presentation of the results. Really fascinating, and I would very strongly recommend to everyone to download and take a look at the report in detail. Some great findings there. So a couple of questions. Yes. First, so this may be a question for Jessica. in the findings, it seemed to be a clear indication that there had been an impact on funding levels. And just wondering if, based on the data that you were able to gather through this study, was there any indication of where there was more or less impact on funding as a result of counterterrorism laws and policies? A second question, and this may be more for Naz. We have Mark asking about to what extent we can be assured of the, as he says, legal supremacy of IHL, international humanitarian law, in situations where IHL may come into contradiction with national legislation, for example, on issues related to counterterrorism. How does that relationship look between IHL and national law when they come into conflict? So perhaps first to Jessica and then to Naz.
Sure. So I think in our survey, we did not see clear information in terms of what areas are perhaps not getting specific funding, or where activities are being curtailed, except in the sense that respondents noted certain high-risk environments. And so there was some mention of Syria, Turkey. That came up quite a bit in terms of the open-ended responses, but nothing specific in terms of particular regions or areas as such that were not receiving humanitarian assistance.
Okay, great, thank you. And over to Naz then from this question from Mark, and for some context, Mark is working with an INGO currently based here in Switzerland at their headquarters.
Great, thank you so much. It's a great and a difficult question, so I'll try to tackle it briefly. So Mark's question, just to reflect back as I understand it, is what is the relationship between these counterterrorism regulations and international humanitarian law, and then can humanitarians be assured that IHL trumps, for lack of a better term? So the answer to the first question is there is quite a bit of disagreement on that issue. So some would say that the spirit, if not the letter, of international humanitarian law preserves a space for independent humanitarian assistance in situations of armed conflict, such that any laws that would restrict that space are presumptively problematic, if not in direct tension with international humanitarian law. While that's an appealing approach, our research has indicated that as a legal matter, it is a difficult one to hold up. Rather, one has to look at specific aspects of humanitarian action that are mentioned in international humanitarian law and specifically protected in international humanitarian law, and then try to determine, are there actually counterterrorism laws or policies that contradict those obligations? So let me give an example. An area where we might initially think there is a conflict but actually have a hard time proving one would be if there is an armed conflict in Syria between, let's say, ISIS and the government of Syria. And let's say that the government of Switzerland, which is not a party to the armed conflict and has no direct role whatsoever in that armed conflict, has domestic regulations imposed on its grantees. And let's say those domestic regulations include some measures that restrict the provision of humanitarian assistance in areas controlled by ISIS. By the way, this is completely fictional. If that is the case, it's not at all clear that Switzerland has any IHL obligations vis-a-vis humanitarian action in the conflict. And second, it's not clear that restricting how it gives money to humanitarian assistance would in any way be problematic under any kind of general obligations it might have as a high contracting party to the Geneva Convention. So in that sense, it's been very difficult to argue that donor restrictions, particularly by states that are not party to a specific armed conflict, are in tension with IHL. Let me give an example where we do see a direct tension. IHL has a range of very specific protections for the provision of medical care in armed conflict, including medical care for wounded fighters. And as I hope we all know, IHL does not draw a distinction between quote-unquote terrorists and other types of fighters in a situation of armed conflict. If there is a law that would criminalize or indeed see as targetable individuals who are providing needs-based medical assistance in a situation of armed conflict to individuals who are designated as terrorists, that might be a real conflict or tension between international humanitarian law obligations and counterterrorism approaches or policies. So in short, it is very difficult to find head-to-head legal conflicts. It is much easier to argue that there is sort of a generalized tension between counterterrorism and IHL when it comes to this question of material support or benefits being provided to members of terrorist organizations. Now, who wins at the end depends who you ask. So there are certainly those in the counterterrorism community who would argue that if a counterterrorism approach is enshrined in a Chapter 7 Security Council resolution, then according to Article 103 of the UN Charter, that resolution in fact overrides any potential contradictory language in international humanitarian law. That's a very extreme position. We haven't heard it very often. A middle ground position might be, well, yes, there may be a tension, but it will be up to the humanitarian organization to figure out where do the obligations lie, and in most cases, a humanitarian organization is going to have clearer obligations under their donor contract or under domestic law than under IHL, which does not create specific obligations for humanitarian actors in most cases. So we don't know the answer to this question, but our research and the research of other organizations certainly indicates the main battleground for this issue has not been IHL. And in general, counterterrorism laws and policies have managed to, some would argue, erode IHL or erode respect for humanitarian assistance under IHL, but have managed to escape coming into direct conflict of legal obligation between the two regimes. Over.
Okay, great. Thanks so much for that. We have a comment that leads into a question that's coming in from Marina. Marina is pointing out that, as far as she understands, an essential way of working for humanitarian actors is to work through negotiation, through dialogue with all parties to conflicts, including those who may be designated as, quote, terrorists. And she's concerned about the possibility for humanitarians to continue in their work if they cannot, quote, speak or engage with designated terrorists. And it leads to a question, and I know it's one that we've discussed in many sessions with colleagues from PILAC and also in some of our workshops about the distinction between speaking with those who are designated as terrorists and actually material support or other connections. Is it still the case that that you see in your work a very clear distinction between the two, where there is actually more maybe even a misconception in some cases among humanitarian actors that actually speaking to designated terrorists is not allowed, whereas actually it's more about material support? Or do you see the actual legal landscape shifting, or at least the policy framework shifting to the point where we should actually be concerned about mere engagement?
Okay, so I will try to give the bad news and then the good news version of our reflections on this question. The bad news version is there are certainly contexts in which engagement and speaking, in our experience, have become problematic, and I'll just say a few. One is where there are regional or case-specific regulations, either self-imposed or imposed through contract on humanitarian actors. So, for example, in the Gaza Strip, UN agencies, some INGOs, and certainly some donors impose restrictions on engagement between senior humanitarian staff and senior Hamas leadership. This is not based on any law, but has been enshrined in contract and in some domestic, parliamentary, and other measures regarding humanitarian assistance in that specific case. Second, where engagement and negotiation involve flights, car rental, buying lunch, paying per diems, these ancillary activities may run into conflict with either Security Council imposed asset bans and travel freezes, or with individual states' counterterrorism laws. So humanitarian actors may be well advised in specific contexts to be cautious that speaking is only that and does not involve the provision of other ancillary resources to those that are being engaged with. Finally, there is a sense that at least some states do indeed have measures that appear to restrict meetings or facilitating speech, but these actually are very, very uncommon. The good news, there does, as Ann suggested, seem to be a lot of misperception amongst the humanitarian community on this question. We have heard in meeting after meeting senior humanitarian actors indicating that negotiations are illegal or speaking to members of terrorist organizations is illegal. That is absolutely not the case under most domestic counterterrorism laws and in general under the Security Council counterterrorism resolutions. So speech is in general not restricted by counterterrorism laws and policies. Negotiation as a speech act is similarly not restricted by most counterterrorism laws and policies. And my personal view is that especially United Nations agencies, but also large INGOs, need to be very, very cautious about rumors that can quickly spread in particular field contexts where staff are told that speaking with members of specific organizations is either illegal or prohibited by the UN. It's worthwhile to push back on those kinds of statements, to ask for documentation, and to ask what is the source for those kinds of statements. In most cases, you will find there is no source underlying those statements, and where there is one, it may be worthwhile to seek to understand whether things can be clarified. Over.
Okay, great, thanks. And thanks to everyone for weighing in on the polls. So just to take a moment to look here, Naz and Jessica, we posed the question to the group about ambiguity, a good thing or a bad thing. So I think we're verifying the split that you found as well in your research. A few more people in favor of pursuing clarity, but a good number as well seeing the potential value for humanitarian actors in maintaining some level of ambiguity. So it is indeed a really challenging question, I think, for the humanitarian community. Also now seeing quite a number of people responding that they have been informed that speaking with quote terrorist designated organizations is illegal. So again, verifying Naz, your reflections, and thanks so much for the really informative response there. So we have a question now, I guess going back maybe to Jessica and then Naz, if you have some reflections as well, a question that came in from Kate regarding how states, in particular donor states and UN agencies, have reacted to this study. Jessica, over to you.
Sure. So I think I know that Naz has engaged in a bit more engagement in terms of presenting the study to states and donors, but I think our sense is that we've gotten largely positive reactions and a greater understanding of the costs that we're touching on in some of the responses to the questions, the cost of compliance, the cost that humanitarians are facing in the field.
Okay, great, thanks. And Naz, any further thoughts?
Yeah, just to
further
add,
thoughts from Naz.
Just to add that I think that's right, and I think they were the sense I've had so far in engagements we've had with government donors on this, and I should note we have not yet had the opportunity to brief governments where so-called host governments, so areas where these conflicts are in fact taking place or where the designated groups do control territory. So that's an important thing for me to note. But from donor governments, one, I think they have a sense that there is considerable confusion on their side as well, a real recognition that for many, many government representatives, particularly those that are on the donor side of the House, understanding their own state's laws, regulations, and policies and how they impact humanitarian partners has been a real challenge. And they have their own internal communication problems, not so different from the silo effect we've seen on the humanitarian side. Second, I think a particular interest in additional research that would flesh out both the cost of compliance, but also what kinds of activities have been curtailed by humanitarian actors. So can we get more granular in the data regarding the activities, the projects, and the programming that humanitarian actors have either ceased or altered in response to perceived or actual impact of counterterrorism regulations? Over.
Okay, great. So we have time for one more just quick question. It's a great one to end on here, coming from Farzana in the chat. And I see Jessica engaging already in the chat, but great if we can have maybe again first Jessica's reflections, and then to end with Naz for reflections on next steps, as well as any other closing thoughts you'd like to leave us with. So over to you, Jessica, on the question regarding next steps for this track of research at PILAC.
Sure. So I think, as I noted in the chat very briefly, I think we are trying to seek out ways in which we can share the study more broadly with humanitarians, but also states and donors, and as Naz touched on in her remarks, exploring areas for additional research. And we think, in particular, the cost of compliance issue may be one that is very valuable for both humanitarians and states to consider and sort of quantify to really understand perhaps where changes to the laws and policies could be beneficial both to states and to humanitarians. I think there's been some ambiguity on this issue, and it's something that's worth exploring further. So over to you.
I'll just say a few more words there. Building on Jessica's comments about doing further research on the cost of compliance, we've had some interesting interactions with experts on contract law, and they have indicated that there may be creative ways to do this research without having to go to humanitarian actors and ask, could you please itemize for us all of the activities that you've done that are unlawful and tell us, how much they cost or how much you've spent in order to document them differently, right? So one one would not want to engage in research that would create risks for humanitarian actors. And I think we'll be looking to other fields in order to identify methodologies that can both create a sense of security for our interlocutors, but also hopefully allow us to add more empirical data to the discussion. Second, we've been conducting research on the question of exemptions to to counterterrorism laws and policies for a few years now, and I think our sense is that much of that, the future of that policy debate and policy action on the issue of exemptions hinges on whether or not the humanitarian sector can come together to make some crucial political and strategic decisions on these issues in the year or so to come. So we've been hearing from many in the community that their sense is that counterterrorism restrictions are becoming ever more stringent, restrictive, and that donors are more and more concerned about diversion or resources flowing to terrorist actors in light of the current geopolitical and security environment. And if that is right, then our sense is that there may be a real moment in the 12 months or so to come where the humanitarian sector will need to decide either this is an urgent policy matter that requires some kind of collective decision-making and action, or organizations decide not to pursue this as a collective, and silos remain silos, and organizations figure out on their own how to deal with these issues and take the risks that are attendant with that kind of approach. So we're excited to continue engaging with humanitarian actors on this, and certainly we think that PHAP is an absolutely vital forum for not only awareness raising and knowledge exchange, but also better understanding how professionals are grappling with some of these incredibly difficult challenges. Thanks.
Okay, thanks once again, Naz Modirzadeh, Jessica Burniske. Great to have you with us once again, and very interesting to have this presentation of the results of your research. And I know at PHAP here and throughout the membership and broader network, we're very much looking forward to continued engagement and working together with PILAC and benefiting from the research that you're doing. So thanks so much, and thanks once again for being here. To all of our participants, thank you again very much for joining, for actively participating in the discussion. We look forward to following up with you. You'll receive by email the links to the audio and video recordings of today's event, as well as the mentioned resources. Those will also be available on the event page. You see the link there on your screen. And we did also want to highlight for those of you who are interested in taking a deeper dive into these and related questions, we have a thematic workshop coming up in July, the 6th and 7th of July this year, taking place in Brussels, looking at the implications of terrorism and counterterrorism for humanitarian action. That will be part of a week-long series. It will follow directly on a 3-day core professional course on humanitarian law and policy, the 3rd through 5th of July. So for those who may be interested in joining us in July, we have a few seats left, and feel free to read in more detail about the workshop and the preceding course on the event page on the PHAP website, and to submit your application as soon as possible. If you're interested in discussing in more detail with us the content of the course, do also just get in touch by email or by phone. So with that, I think we'll call it a day, and we'll look forward to welcoming all of you again very soon in the next event in this Advanced Practitioner Series. Thank you very much, and thanks to our team here at PHAP, Marcus and Liz, and this is Anne Lang signing off from Geneva.